Hello, this is Scott DeMarco. I'm a financial professional who performs business valuation and divorce accounting for litigation matters and collaborative divorce. I'm joined by JoAnn Shartrand, an experienced matrimonial attorney, mediator, and collaborative attorney in New York. We will be presenting on the topic of options for divorce in New York State, comparing mediation, litigation, and collaborative divorce, and the do-it-yourself method. With that, I'd like to turn it over to JoAnn Shartrand.
Thank you, Scott. This is JoAnn Shartrand, and I am a matrimonial law attorney. I've been practicing law for 31 years. I'm also a divorce mediator, and I've been doing mediation for 20 years, and a collaborative divorce attorney for 9 years. Again, thank you for being here with us today. This is a program for people considering a divorce. And although we understand that some people have not yet reached the decision to divorce, we won't be covering any topics relating to marital reconciliation. This program is only about divorce options. So on this slide, every 10 minutes, 24 hours a day, 365 days a year, there is a divorce in New York. One of the reasons for the uptick in divorce is that in 2010, New York State passed no-fault divorce. Prior to 2010, in order to get a divorce in New York, you had to show a fault. So we oftentimes would have divorce trials where the issue was whether or not the parties would actually be entitled to a divorce. So unless the couple consented to the divorce, one party had to be at fault. That is no longer the case. Now in New York State, in order to get divorced, one party just needs to ask the court for a divorce and the divorce will be granted. So the issues in divorce now surround parenting of the children, support for the spouses and the children, division of marital property, and division of debts. As a result of that, it is really important, the most important decision that you will make in a divorce now is what process that you will use for divorce. Many people in determining and deciding on the process have concerns about how the process, how going through divorce will impact your children. Again, you're not alone here. 38% of divorces involve children under the age of 18, and actually a significantly additional number involve children between the ages of 18 and 30. In New York State, 37,800 children are affected by divorce. One of the ways that you can alleviate that effect on children is by choosing the correct process that's right for you. I wanted to start by going through the 4 different available processes in New York. The first one is do-it-yourself. The second one is mediation. The third one is litigation. And the last one is collaborative divorce. First, the do-it-yourself divorce. In New York State, we call this representing yourself pro se. In New York State, the Office of Court Administration has some complex generic state forms that couples can use themselves to prepare uncontested divorce paperwork. However, these forms do not involve issues about dividing your property, parenting your children, support, and maintenance. And in fact, if you go on to the state forms, typically they will tell you that if you have a complex financial situation, children, or any domestic violence, you should not use the forms. This can be an appropriate process for couples who have not been married very long and have a very non-complex situation. You do have to be careful, though, because although it's inexpensive initially, if you do use these forms in situations where they're not appropriate, such as complex financial issues, then what we see is there's a high rate of post-judgment issues and complications, and I can tell you from my experience that they will cost 3 or 4 times more than using the correct process to begin with. The second available process for divorce is mediation. And I am a mediator and I do quite a bit of mediation, and for many couples, mediation can be an appropriate process. In mediation, if you look at this slide, what you'll see is 3 people sitting in a conference room. So the one person in the middle is a neutral, and that person can be an attorney. It could be a family professional. It could be a financial person. but is a neutral third party that's there to assist the couple in discussing what issues have to be resolved for their divorce and helping them reach a resolution about those issues. Now, mediators are there to help the couple compromise. So they're not guardians of each person's individual rights. So they're not going to be looking out for you specifically and individually to make sure that everything that happens in the resolution of your divorce happens in your best interest. Also, attorneys are usually not present in the mediation sessions. And for many couples, this can give them a lack of confidence because they're not good at discussing and negotiating. They don't like to sit across from their spouse and have these conversations. And they're not provided with legal advice at the moment. Finally, mediators do not provide legal advice. They can give you some basic information, but they are not there to represent you individually. Usually in a mediation process, you are allowed to go outside the process and speak with an attorney, but attorneys aren't in the session with you, and mediators do not provide legal advice. The next option for divorce in New York is litigation. And litigation is what most couples will know as going to trial. Now, as I said before, since New York has no fault grounds, when you go to trial, the issues are not fault. They're not what your spouse did to you that led you to come to court that day. They are issues involving the division of your assets, child custody, child and spousal support. In order to get to trial, though, there is a lengthy period of time and extensive discovery to get to that day. And so the court requires quite a bit of paperwork to be exchanged and financial information exchanged. Sometimes there are pretrial motions. There typically are 3 or 4 court appearances before the actual trial date. Once you get to the trial date, it's also not conducted usually on the same day. And so there will be a pretrial conference, and then there will be another day where you might have some of your trial scheduled, and then you might not get another trial date for several months, and then you'll have another trial date. And then also at the end of your trial, the court has to make a decision. And most judges are now taking between 6 and 18 months to make a decision after trial. So the litigation option tends to be costly because there's a lot of financial paperwork and a lot of court appearances, and confrontational. In a litigation case, usually people back into corners and are very positional about what they want, and it's extremely unlikely that the parties will agree to a compromise. The court also dictates the pace, so the court will tell you what day and what time that you have to be there for all of your court appearances and your trials, which means that you will have to take extensive time off from work. Finally, there are unpredictable results. Judges tend to make decisions based on their own life experiences, and they may not do what the two of you feel is in the best interest of your family and your children.
And JoAnn, just a quick question. What percentage of cases, in your experience, do you think settle before a judge actually renders a decision in a case?
I'd say a large percentage do. However, what I'm finding now is that many matrimonial attorneys are intentionally not settling cases until the day of trial. So you're still really looking at probably a 6 to 8 month period of time to get that to that point in time, and a lot of work that's done during that 6 to 8 month period that tends to be not very productive and very costly. The final option for divorce in New York is collaborative. And we're going to be going through collaborative in much more detail, but just to give you a basic summary, there are no court appearances. The clients set the pace. All the needs of the family are considered. We use family professionals. We use neutral financial experts, and it's very emotionally supportive. First, with regard to collaborative, there are 4 core principles. And the first core principle is that the collaborative process provides resolution outside of court. So you'll see on the one side of your screen, there's a picture of a courtroom. which is even if you go for court appearances, many times you actually have them in the courtroom, and that's what a typical courtroom looks like in New York State. And on the other side of your screen, you see a conference room with the parties and professionals having a conversation. And this is what our collaborative rooms look like. The second core principle are that collaborative teams are extensively trained to manage the content and process of divorce. And this is really important because all of the collaborative professionals in the Capital District started off in a basic collaborative training and have had additional collaborative trainings as a team. So we get together periodically as a team to train to help manage your divorce and manage the process of your divorce.
And JoAnn, why do you think it's important that the professionals involved have a working relationship, know each other, you know, as opposed to maybe two attorneys who have never met before and are trying to settle a divorce?
Well, first of all, there's a certain level of trust, and trust is really important in a divorce because if someone feels that they're not being provided with appropriate financial disclosure, or somebody is trying to do something behind their back, they're less likely to settle than if the team has worked together and knows that everything is being managed honestly in an upfront manner. Also, to be trained together is important because we learn similar procedures for how we're going to conduct collaborative matters, and everyone is on the same page about how we're going to do that.
That's great.
Core principle 3, transparency. And this is kind of getting back to providing financial disclosure, complete financial disclosure. And actually, maybe I'll ask you a question, Scott. How do you work as a financial neutral to ensure transparency when it comes to the financial disclosure?
Right. So as the financial neutral, what I do is really work with the clients to gather all the financial documents that are available. And I've had many cases where there are concerns that maybe there are some hidden assets or hidden income or something like that in a collaborative divorce. So what we do is we just say we have to have complete transparency until everyone is completely satisfied with the process. And what I found in working in these collaborative divorces as a financial neutral is that I get a lot more discovery, a lot more documents. I'm completely open to speaking with the accountants, the financial planners. I get statements going back as far as we need. And everything really kind of comes to the table. And it's at a fraction of the cost of what it would be in a litigated process, where litigated process, there's discovery demands back and forth and objections, and it's a very lengthy process. So we're able to shortcut the process and just have everything out on the table and deal with any issues that do come up. So I think it's in the collaborative process, there's complete transparency, and it's much less costly on the discovery side.
Yeah, this transparency also relates to how the couple is going to deal with each other. So what we really try to do is make sure that no one is ambushed with information that they haven't had a chance to learn about prior to the meeting and be able to process. Core principle 4, the parties and all needs are treated respectfully. So not only are they treated respectfully, but they're all needs are considered. So we don't look at just one person. We don't look at the wife and just deal with her needs and desires, or the husband just deal with his needs and desires. We interrelate everything. So you can see these puzzle pieces fitting together. So when we discuss what the needs of the wife are, we'll also consider the children's needs and the husband's needs, their needs to co-parent together, the interrelationship of their finances, so these things can be done, and what's the best way to divide their property to work so that everyone's interests are all taken into account. This complicated chart is meant to show you what it would look like if you went through the court system. So you're not really intended to understand it because it's very confusing, and they really need to do a lot of work in New York State on how they handle divorces. The first at the top of it, we have retaining the attorney. And then you look at the different issues to resolve. They actually have 2 different court systems in New York. So if your only issues are custody and support, you can go into family court. I have some couples that actually aren't married that have been in domestic partnerships with each other and have children together. So they would go through family court and a family court judge. But the judge hears the custody issues in family court, but they have an additional person called a support magistrate that actually hears the support matters. So even in family court, there are two different people. Now, if you need a divorce, sometimes you can have part of your case heard in family court, and then it gets rolled over into Supreme Court for your divorce. And there's a whole procedural process that you have to go through in Supreme Court. There's what's called pleadings, things like summons and complaints and answers and replies. And like I said, sometimes there's motion practice. There's pendent lite motions for relief in terms of parenting or support. There's typically an attorney that's appointed for your children, somebody chosen by the judge to represent your children's interests. And then there's discovery, which is exchanging financial information, responding to lengthy discovery demands. And typically it involves seeking out financial documents that aren't necessarily even relevant to the case. 5 years of tax returns, 7 years of bank account statements. Just because the court system has a certain amount of discovery material that has to be provided, we tend to end up with a whole stack of paperwork that is required by the court system, but not necessary to resolving the case. And then we have to have things valued. So typically we have appraisers and pension evaluators and business evaluators. Sometimes we have psychologists that come and testify about the children's needs. In the end, there tends to be winners and losers. And I find that most of my clients who have gone through a full trial, neither client is happy with the judge's decision, because the judge makes a decision based on what he thinks or she thinks is right for your family and not what they think. So I want to talk about the different professionals in a collaborative case, and then we'll talk about each one of them individually. What is the role of the attorney in a collaborative case? The attorney provides legal advice and advocacy for the client. So is there to give you what you need to understand the law. The attorney will also manage your expectations. So in providing you with information about the law, will also give you information about the different settlement options and whether they're realistic, whether the things that you are asking for are realistic under the law. And then finally, when settlements are reached, the attorney will draft and or review all legal documents. The family professional, these people usually will facilitate the meeting. So when we all get together and meet, they run the agenda. They also will promote effective communication between the participants. They'll keep the process focused on successful outcomes, and they'll provide conflict resolution and emotion management skills during the meetings. And then finally, Scott will talk about this a little bit more, I think, in detail, but do you want to just summarize the financial neutral?
Sure. So the financial neutral is jointly retained by both of the clients that are going through the divorce, gathers the relevant financial documents. Some financial neutrals can value certain assets, value businesses, and those types of issues. Do tax calculations right at a meeting, so you don't have to have reports written necessarily, away from table. You can really do a lot of the calculations right at the table to try to streamline the process. And the financial neutral also helps with some of the issues such as spousal maintenance, child support, those types of items, and it really tries to look at different options that are available that meet everyone's needs. We'll talk about it a little more.
The family professional. Usually we have a family professional with us, but we don't today. So I'll talk a little bit about what the family professional would do. The family professional starts by meeting with the couple to put together goals and values. And that's a statement of things that both of you agree are important to you. So they can be things like, we agree that we don't want this process to impact our children. We agree that we both want to be financially secure in our retirement. We agree that one party will retain the family home. So once these goals and values are developed, we use those goals and values in the actual meetings, settlement meetings, to determine how we're going to talk about different things and the priority that we will have in those discussions. The family professional will oftentimes develop your parenting plan. So they will sit down with the two of you, talk about the needs of your children, and actually put together your parenting plan and bring that into the meeting. They also, as I said before, they facilitate the team meeting. So when we all meet together, the family professional will run the agenda. They assure effective and productive communication in the process and beyond. So during the meetings, if there is inappropriate communication, the family professional would intervene to hope to streamline any problems. And in between meetings, oftentimes there are reasons why the parties would want to meet with their family professional or professionals to help them with parenting conflicts and other issues that arise. They'll utilize, obviously, their expertise in knowing the emotional stages of divorce and how to help people be ready to discuss divorce issues. And they're going to ensure a respectful environment during the meetings.
And JoAnn, how important do you think family professionals are to the process?
Well, I always say that family professionals, if we had a 50 to 70% chance of settling a case, if we add a family professional, that increases it to almost 100%
Wow.
chance. So
okay.
That's how important they are.
And then I'll talk a little bit about the financial neutral. As I mentioned, there's just complete transparent financial disclosure. So it's really disclosing everyone's income, disclosing assets and liabilities as of a certain date. So really kind of streamline that process. You have one person gathering documents and working with the attorneys to make sure that all the legal requirements are met, so that there can be in many cases, a joint statement of net worth prepared, rather than having two separate statements of net worth. And it's really supposed to be prepared so that it's specific to the divorce, as opposed to what the courts would be looking for. It's in regard to statutory statement of net worth. One of the very important things that a financial neutral can do is look at a specific settlement scenario and forecast that out for the remainder of a person's life. So we'll look at, these are the assets you're getting liabilities such as a mortgage on a house. We'll work with the person to create a prospective budget on a go-forward basis, and we'll forecast out what that settlement looks like for them based upon ranges of spousal maintenance and child support to see if it meets their needs. And on the flip side, we'll also look at the person who's paying the child support and maintenance and see if they're able to meet that need. So it's really looking at it from both angles to make sure that it makes sense for both people that are coming to the settlement. There's many common pitfalls that can occur. Most of them relate to taxes. So there are many things that we look at specifically, and the financial neutral is right there at the table saying, if we're coming up with some type of creative option, is it really going to work for financial and tax purposes, or is there going to be some rule or law that's possibly being broken or bended that could create a problem? And we really look at both clients' needs and what they think are good, not just for them, but for everyone involved in the process. So it's trying to come up with some type of creative solution that really works for everyone, as opposed to a judge who really, is doing their best, but doesn't necessarily know exactly what the clients really want on the list of 50 to 100 different things that are taking place, different decisions that they have to make in a divorce. So it's really putting the power in the client's hands and giving them options and different things that we've seen in other matters that could save them money on taxes, save on different issues in the future. So really trying to come up with those creative solutions actually at the table.
Now, Scott, I also understand that in addition to doing collaborative, you provide expertise in litigated matrimonials. Can you tell me a little bit about what you see when you go and testify in those cases?
Sure. Yes. Most of my practice actually is in a litigation environment. So it's very much working as a financial expert witness. So what that means is that I will issue document requests. Many times it's, multiple document requests. I will submit deposition questions that will be asked of someone, if they have a business, if there's questions on certain financial issues. We do it in a litigated process. It's very formal, and that means that there's many people handling those document requests, those questions. So I'll initiate the question. Maybe it'll go to an attorney who will draft it into a letter, or they'll put it into a deposition question. That question will get asked by the attorney at the deposition. The other attorney may object to the question and go back and forth, and then they'll have to, maybe do motion practice to gather additional documents. There may be subpoenas issued. And so that takes a very long period of time, as opposed to in a collaborative divorce. It's just me dealing with the clients directly, or their financial people and accountants, gathering the documents and really streamlining that process. And then I also testify at trial. And I can tell you, in the trials that I've testified at last year, they were 3 years in the making. So it took 3 years to actually get to trial for me to testify. And for a judge, then it took months for the judge to analyze all the information, write a decision, and then there could be the possibility of appeals beyond that period of time. So collaborative it seems like there's a lot of professionals involved, but it's very streamlined. Everyone's doing exactly what they need to do to move the process forward.
I think a lot of people feel that judges come into their job knowing everything about the subject matters on which they make determinations. But the fact that people pay a lot of money to bring you in as a financial expert leads me to believe that you're there because you're required to educate the judge on the financial issues of the case. Is that correct?
Yep. Yeah, that's exactly right. I mean, I'm there to help educate the attorneys and educate the judge on a lot of times, some very technical issues. It's in a courtroom. The facts, do come out, but it's sometimes not in the fastest process to actually have that information come out. And the judges are doing their best to understand, if, for example, a business valuation, I've presented seminar after seminar. I've taken years of training on many certifications. So it's a very complex and technical situation. And a lot of times the clients are best armed themselves to actually, make the decision on a lot of these topics.
And isn't it also the case that usually in a litigation matter, there's another financial expert on the other side with sometimes a contrary point of view?
Yep, and that's unfortunately what happens sometimes, is that the financial experts could arrive at very different opinions of value, opinions of income, if you have a vocational expert that's coming in to assess income. And then a judge has to make a decision as to which expert is correct, or take one of the experts' methodologies and adjust that methodology to arrive at what the judge thinks is the right number. And a lot of times it's not exactly obvious. So it's a situation where it is highly complex, and a lot of times it's just easier, like in a collaborative divorce, just to have a conversation about it, and then you can share it with accountants, share it with a financial planner, other people, and really try to get to the bottom of the issue together. Mm-hmm.
Sometimes people express a concern about collaborative divorce because when we identify the different members of the team, people feel that the team has too many members. So what I wanted to show everyone with this slide is the difference between the team members in a collaborative team in litigation. So in a collaborative team, the wife would have an attorney, the husband would have an attorney. We would either have one family professional or two family professionals. We would have a financial neutral and just other neutral professionals as needed. So if the couple decided that they needed to have their house valued, they would hire an appraiser just for the specific purpose of appraising that house. In a litigation case, the wife and the husband would each have their attorney, And then there would be an attorney for the children. And I can tell you, the last thing you want is an attorney appointed for your children, because it gives your children sometimes an extensive voice. And people have to understand that if their children are over the age of 10 in New York, then sometimes their voice on where they want to reside and under what circumstances can control. Also, in addition to that, sometimes there are psychologists who evaluate the whole family and issue a report to the court. And if either party has any mental health issues, then sometimes they have to go to a separate mental health evaluator. Then, as Scott described previously, the wife would have her financial person and the husband would have his financial person. And then the parties would have to subpoena witnesses, because everything in court has to be proven. And it has to be proven either by a person coming into court and specifically testifying to something, or by documents which meet pretty strict evidentiary rules. Sometimes there are investigators. Scott talked about depositions, where you take the testimony of parties and witnesses before trial, and that usually involves a stenographer who will then come and take down the testimony and put it in a written form. If the wife wants to have property appraised, then typically the husband will have a separate property appraiser. And the same thing with businesses. So as you can see, the litigation team can easily be 2 or 3 times as many members involved as in a collaborative team. The costs of each option. We don't have do-it-yourself on here, but obviously that would be the least costly, because since you're doing it yourself, you would just be paying for the filing fees. But even with the do-it-yourself model, there's about $400 in costs and filing fees that you have to pay. Mediation would be the least costly of the options. Typically, mediation, you're sharing the cost of the one neutral. Sometimes in mediation, though, you do have to retain separate attorneys to review documents and give you advice as it's ongoing. And sometimes you still do have to have, most of the time, you have to have properties appraised. And we also sometimes will bring a financial neutral into mediation. Collaborative is more costly than mediation, because we do have the team meetings where each of your separate attorneys are both at the team meeting. So instead of just paying for one neutral, you're paying for 2 financial professionals. So if we're going to put dollar values on it, I would say mediation would range between $3,500 and $5,000. Collaborative would probably range between $7,500 and $15,000. An attorney negotiated settlement, that's where you hire attorneys and you're in a litigation process, but you negotiate that. That's probably going to range around $30,000. And for full-scale litigation, it can go anywhere from $50,000 to, you have people down in New York City that have a lot of money and they spend millions on their divorce. So it gets out of control because there really isn't any way to structure it in a way to control those costs.
Right. And JoAnn, you could have actually a combination here. A lot of people that are in an attorney negotiated settlement could go to mediation for a little while and then come back and then go to settlement or full term, full scale litigation too, right?
Yes, that's true. So we can combine, the idea really with providing the different options for divorce is we want to choose the option that's most appropriate for you and your family. And so some of these things can be combined. I think the key really is to stay out of court, because that's where you get into a lot of the costs. But mediation, collaborative, and attorney negotiated settlement can be interconnected and combined in a way to provide the best for the couple to meet their needs. So I wanted to just tell you a little bit about what happens in a collaborative process once we have the team assembled. The first thing is, it says we establish the framework. And what that means is the family professional brings into the meeting the spouse's shared goals and values. And we use those goals and values to put together the agenda for what we're going to discuss and when. And then we gather the information that we need. So if we're going to be talking about maintenance and child support, then we probably would need some tax returns and W-2s and paycheck stubs so that we're able to have a discussion about that area. From there, we discuss each party's interests, needs, and values. So each party individually would discuss their interests, needs, and values, and we would try to identify shared interests, needs, and values, and use those shared interest, needs, and values to brainstorm different settlement options. So the idea is there may be 2 or 3 different possibilities for how you could settle an issue. And from there, we would negotiate, hopefully, the best option for the couple, and put together an agreement based on that resolution reached. Once there is a resolution, then the attorneys would be involved in preparing the legal documents and divorce papers for court approval.
All right, JoAnn, I really appreciate your time today. I think it's been great learning a little bit about the different options for divorce in New York State. We will actually post a couple links on this presentation following this so that you can gather some additional information on it. So thank you very much.
Yes, thank you for being here today. And I just wanted to let anyone know that they're welcome to either call Scott or I with any additional questions that you have about the process.